Hey everyone, and welcome to this explainer. I'm genuinely thrilled you're here with us today because, wow, we are tackling a truly monumental topic. We're going to trace the epic 250-year journey of the Indian justice system. We're talking from its very first origins under colonial rule all the way up to the modern constitutional framework we see today. And maybe most importantly, we're going to break down those massive 2024 legal reforms. These changes literally rewired how justice is delivered to 1.4 billion people. So let's jump right in. Okay, let's dive into this. Here's a quick roadmap of what we're covering. First up, the colonial roots to the Constitution. Second, civil and criminal court processes. Third, the massive pendency crisis. And finally, the 2024 criminal law reforms. Section 1. Colonial Roots to Constitution. You know, our modern legal framework didn't just appear out of thin air in 1950. Tracing the timeline back, today's highest courts are actually the direct descendants of the British East India Company's really early attempts to impose order. In 1773, the Regulating Act set up the very first Supreme Court at Calcutta. Then, fast forward a bit to 1861, and the High Courts Act started unifying what was a super fragmented system. Later, the Government of India Act in 1935 established the Federal Court, which was pretty much the direct precursor to the modern era. And then, finally, in 1950, the Supreme Court of India was officially inaugurated. It completely transformed from a colonial instrument into the independent guardian of a brand new free nation's constitution. Now, what's really interesting about this is just how much of that history you can still see today. The modern Indian judiciary still actively wears the physical and procedural hallmarks of its colonial past. The entire system is built on common law jurisprudence, meaning it relies heavily on past precedents. And if you step inside a courtroom today, you're still going to see those black robes and white bands. You'll hear judges respectfully being called your lordship. You'll notice really strict rules, like an absolute ban on photography anywhere on the premises. And get this, until very recently, foundational criminal laws, like the Indian Penal Code of 1860, were over 150 years old. All right, moving on to Section 2, Civil and Criminal Court Processes. So, how does an everyday citizen actually navigate this historic institution today? Well, first, we've got to draw a super clear line between the two main branches of the system, civil law and criminal law. Think of civil law as being fundamentally restorative. It deals with private disputes, things like property issues, breached contracts, family law. The whole goal is just to return the injured party back to their original position, usually by having the other side pay compensation. Criminal law, though, is entirely punitive. It's the state prosecuting an accused person for offenses against society as a whole. The focus here is all about determining guilt and, if they are guilty, handing down a punishment, like actual imprisonment. Okay, so if you're a civil litigant, the journey kicks off with filing what's called a plaint. And honestly, this step has been heavily modernized to meet 2026 standards, mostly through digital filing right on the National eCourts portal. Pretty convenient, right? Next up, you have to pay the required court fees. These are often ad valorem, which is just a fancy way of saying the fee is based on the actual monetary value of the dispute. After that, you enter the trial phase to present evidence and ultimately reach the judgment where a remedy or compensation is officially awarded. Now, for criminal cases, the stakes are a person's actual liberty, so the flow looks quite a bit different. It pretty much always kicks off by filing a First Information Report, or FIR. That's the spark that sets off the police and forensic evidence gathering. If charges are actually framed against someone, it moves into the criminal trial itself, which leads to closing arguments, a judgment, and finally, the absolutely crucial right to appeal. And this brilliantly illustrates the sheer gravity of that judgment stage we just talked about. Once all the evidence is finally laid out on the table, both parties make their closing statements. This right here is the critical make-or-break moment. The judge has to carefully weigh every single piece of information to deliver a definitive verdict, meaning it's either an outright acquittal or a conviction followed by sentencing. But the system does build in some really vital safeguards. If a party is dissatisfied with the judgment, they don't just have to accept it. They have the right to escalate their case. Through an appeal or a revision petition, higher courts, like the High Court or the Supreme Court, can step in and review the lower court's decision. This ensures that absolutely no procedural error or miscarriage of justice slips through the cracks. That brings us to Section 3, the massive pendency crisis. 54 million. Yep, you heard that right. According to recent data from 2025 and 2026, there are over 54 million pending cases jamming up the Indian judicial system right now. Honestly, just let the sheer mind-boggling scale of that backlog sink in for a second. We are talking about an 80% increase in just the last decade alone. It's wild. So if we break down where this massive bottleneck is actually happening, the data is super revealing. While the Supreme Court is handling over 88,000 cases, and the high courts have about 6.3 million, the vast, overwhelming majority of cases, literally 48 million of them, are stuck right at the foundational level. I'm talking about the subordinate district courts, and the numbers show us that criminal trials make up the largest chunk of this lower court backlog by far. So, the crucial point is, why exactly is this happening? If we impartially look at the systemic drivers here, a few main root causes really jump out. First off, it's a pure manpower issue. India is operating with roughly 21 judges per million citizens. To put that in perspective, the global standard is closer to 50. And in early 2025, high courts were facing a massive 33% vacancy rate. You combine that kind of shortage with antiquated procedural rules, a culture of frequent, unnecessary adjournments, and a huge volume of appeals filed by the government itself, well, it's no wonder the system just grinds to a halt. And the human cost here is immense. Reports indicate that around 77% of prisoners in India are currently under trials. That means they're sitting in jail just waiting for their day in court. Like they say, justice delayed is truly justice denied. Which leads us perfectly into Section 4, the 2024 Criminal Law Reforms. Let's move to the government's response to this staggering backlog and see how this builds on what we just discussed. To really understand these massive 2024 reforms, we have to look at how three foundational 150-year-old British-era laws were entirely scrapped and replaced by three new Hindi-titled codes. The Indian Penal Code was replaced by the Bharatiya Nyaya Sanhita, or the BNS. The Code of Criminal Procedure was replaced by the Bharatiya Nagarik Suraksha Sanhita, or BNSS. And finally, the Indian Evidence Act was replaced by the Bharatiya Saksha Adhiniyam, the BSA. All right, let's start with the BNS. This is the substantive law that actually defines what crimes are. Right off the bat, the very name represents a huge shift, moving away from simply being penal or focused on punishment to nyaya, which translates to justice. Substantively, this new code completely removes the old colonial-era sedition law. It replaces it with offenses specifically targeting acts that endanger the sovereignty and integrity of the state. It also officially defines modern threats, like terrorism and organized crime, right inside the general criminal law for the very first time. And, in a really big step forward for rehabilitation, it introduces community service as an actual punishment for minor offenses. Next up is the BNSS. This code directly attacks that 54 million case pendency crisis by focusing heavily on procedural speed. For instance, it legally mandates what are called zero FIRs. This means you can report a crime at literally any police station, regardless of their specific jurisdiction. It also requires the police to give victims progress updates within 90 days. And, crucially, it imposes incredibly strict statutory deadlines, like legally requiring judgments to be pronounced within 45 days after a trial wraps up. Finally, we have the BSA, which deals entirely with evidence. With this reform, the balance of justice has officially stepped into the digital age. This is a total game changer because it explicitly grants electronic and digital records. I'm talking server logs, emails, smartphones, digital signatures, the exact same primary legal status as traditional physical paper documents. It fundamentally modernizes the entire process of how guilt is actually proven in a 21st century courtroom. So, that brings us to our final thought for today. We've traced the colonial roots, walked through the procedural pathways, stared down that crushing 54 million case backlog, and explored the sweeping 2024 reforms designed to fix the whole shebang. The really provocative question we have to leave you with is this: will these modernized laws, strict timelines, and digital integration actually be enough to overcome such deep systemic challenges? Will they finally deliver timely justice to 1.4 billion people? I guess time will tell. Thank you so much for hanging out and learning with me today, and definitely keep exploring the fascinating realities of our legal systems.